Paul Coe was a barrister in New South Wales, and apparently in many ways a really positive barrister with a strong sense of social justice. In the judgment, we read that he gave considerable energy to advancing justice in Aboriginal communities. Barristers and legal practitioners generally, however, are not immune to the difficulties of modern life. Like so many other people in our society, Mr. Coe found himself separated from his wife and going through divorce and property proceedings. As a perfectly normal part of those proceedings, he had to swear an affidavit setting out his financial circumstances. Sometimes those family law proceedings make people act in very strange ways. Emotions are high: grief, jealousy, anger. Who knows what it was, but some factor led Mr. Coe to deliberately swear a financial affidavit which understated his income by half. His actual earnings each year were over $150,000, but his affidavit acknowledged just $70,000. Of course, it all came out, and Mr. Coe found himself reported to the Bar Association and what was then called the Legal Services Tribunal. He was given an opportunity to explain himself, but instead he chose to remain silent, which is always a bad idea in front of the tribunal where there's no general right to silence. The tribunal found that he was no longer fit to practice the law and that he should be struck off the roll. He appealed to the New South Wales Court of Appeal, but the court confirmed the decision of the tribunal. President Mason quoted an earlier decision when he said, "It is of the utmost importance that this court can order its procedures and give its decisions in the confidence that the barristers appearing before it will not mislead it, will conduct themselves in accordance with the law, and discharge their duty even when not subject to scrutiny." From this case, we confirm our understanding of the absolute significance of a legal practitioner's duty to the court, particularly over things like affidavits, which might seem routine, but which are actually crucial and solemn statements setting out true evidence before a court. If a barrister is willing to lie on an affidavit, how can the court ever trust the things that barrister might say during proceedings? Again, we see that the opportunity to appear in court as a legal practitioner is a privilege which carries responsibilities, including the responsibility to be absolutely truthful.